She lost her bakery to 47 words written by a neighbor. She built her business over 11 years. It took one review 47 words long to burn it down. The bakery had been a fixture on Callaway Street since its doors first opened. The owner, a woman who had started the operation out of her home kitchen with a single mixer and a loan from her mother, had grown it into a full-service custom cake studio with a staff of 4 and a wait list that stretched 3 months out. Her reputation was everything. In a business built on weddings and anniversaries and once-in-a-lifetime moments, trust wasn't a feature. It was the product. The dealership sat 6 blocks away. A mid-sized family operation, second generation, specializing in used commercial vehicles. The general manager had ordered a custom anniversary cake for the dealership's 30-year celebration. A tiered design styled after one of their flagship trucks, complete with edible chrome detailing. The agreed price was $1,400. The delivery date was set for a Saturday in early March. The cake arrived, the event happened, and 3 days later, a review appeared on the dealership's preferred business listing platform under the manager's personal account. It read, in part, unprofessional, overpriced, and frankly dishonest. The product was nothing like what was promised, and the owner became hostile when we raised concerns. Save your money. Within 2 weeks, the bakery owner had lost 4 confirmed bookings worth a combined $8,200. A 5th client, a bride whose wedding was 7 months out, sent a cancellation email citing the review directly. The waitlist stopped growing. The phone got quieter. She documented everything. She filed suit seeking $214,000, covering lost contracts, projected revenue loss over 18 months, and damages for reputational harm. Her attorney argued the review was not an honest critique, but deliberate defamation, published with malice after a business dispute the general manager had initiated. On the stand, the bakery owner was methodical. She presented the original design brief, signed and initialed by the manager himself. She presented photographs of the delivered cake alongside the concept sketches. She presented a text message exchange from the evening of delivery in which the manager had written, and this was read aloud in court. "Looks incredible. Everyone loves it. Thank you." She had never been contacted about any complaint, no phone call, no email, no formal dispute, just the review appearing 72 hours later without warning. Her voice broke once, briefly, when she described calling her mother to explain why the waitlist had collapsed. The general manager's defense was not without logic. His attorney argued that the review, however harshly worded, reflected a genuine experience. That the cake had structural issues discovered after the text was sent, that fondant panels had separated during the event, and that attempts to reach the owner directly had gone unanswered. He contended that a business review, even a critical one, was protected expression, not actionable defamation. He characterized the lawsuit as the real act of aggression, a small claims escalation dressed in 6-figure clothing. He was composed, he was credible. And for a time, the courtroom felt genuinely uncertain about which version of events was true. Then the dealership's own event photographer was called as a witness. She had been hired independently to document the anniversary celebration. Under oath, she testified that the cake had remained structurally intact throughout the entire event. She produced a time-stamped photo taken at 7:43 p.m., more than 2 hours into the evening, showing the cake fully assembled, unbroken, prominently displayed. Surrounded by guests, she had not been informed she might be called to testify. She had not spoken to the bakery owner before that morning. She also testified, quietly and without drama, that she had overheard the general manager on a phone call the following Monday, saying the bakery owner had refused to give him a discount on a second order and that he intended to, in his words, make sure that cost her. The defense had no redirect that recovered from it. The judge ruled in favor of the plaintiff. The review was found to constitute defamatory statements made with demonstrable malice, unsupported by the facts and evidence. The bakery owner was awarded $94,000, less than half of what she sought, reflecting the court's measured assessment of documented versus projected losses. But more than enough to signal that the harm had been real and the cause had been deliberate. The general manager did not appeal. The bakery reopened its waitlist 8 months later. 2 of the clients who had canceled reached out to rebook. She accepted one of them. The general manager remains at the dealership. The review was removed by court order within 10 days of the verdict. The question the case left behind isn't really about defamation law or damage calculations. It's simpler and stranger than that. If that photographer had never been called, if those photos had stayed on a hard drive somewhere, would any of us, including the judge, have believed her?